Hi, Assalamualaikum. My name is Nurul Asyikin binti Abdul Hadi. My metric number is 053034. Today, my partner and I will be presenting a topic under criminal law which is regarding to rape. The definition of rape can be identified under section 375 of the Penal Code. A man is said to commit rape who has sexual intercourse with a woman against her will, without her consent, with her consent by putting her in fear of death or hurt, with her consent by way of deception, with her consent that she is unable to understand the nature and consequences of her consent, and with or without her consent when she is under 16 years of age. However, it is not rape for a man to have sexual intercourse by way of provided in section 375 of the Penal Code with his wife who is legally being married. This is provided in the exception under the same section. Nevertheless, it is not applicable where the woman lives separately under a decree from court or a Muslim woman during the period of iddah, and also where the woman obtained court's injunction towards her husband. Now, we go to section 375 subsection A of the Penal Code, which is regarding to against her will. A man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman against her will. In the case of Nasar bin Ahmad, it stated that the act of sexual intercourse was effected despite struggles, protests, and crying on the victim's part. This was sufficient evidence of penetration against her will. It is where the victim had physically protested to such act towards her. Besides, we go to the case of Ku Hang Chua, where there was evidence that the complainant struggled to free herself from the hold of the accused. She beat the accused's hands while he was holding her, shouted for help a few times before the accused tied a towel over her mouth, and struggled again when the accused forced open her tights before she was forced into submission. Next is regarding to without her consent under section 375 subsection B of the Penal Code. A man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman without her consent. A woman consents only if she freely agrees to submit herself while in free and unconstrained possession of her physical and moral power to act in a manner she wanted. Submission mere se will not amount to consent. Even if she did not resist physically and submitted herself, would not amount to consent. It is always a voluntary and conscious acceptance of what is proposed to be done by another and concurred by the former. Thus, a sleeping person can never consent. We go to the case of Rao Harnarain Singh against state. The accused urged the husband to bring his wife to the accused party, where the accused and his friend forced the deceased woman into having sexual intercourse. She cried all night long and died in the morning. There is a difference between consent and submission. Every consent involves submission, but a mere submission cannot be said to involve consent. In R against Oluk Boja, where the emphasis is on the state of mind of the victim immediately before the act of sexual intercourse, it is no defense that the woman consented after the act. Although the victim neither screamed nor struggled and submitted to sexual intercourse without the defendant using force or making any threat of violence, his conviction was fully justified as the victim was tricked into going into the house after having been raped by another man and was frightened when she was dragged into the room with the defendant who was determined to have sexual intercourse with her. The victim was kept there against her will until she submitted, although no force was used or threatened.
Next is regarding to the invalid consent which laid down under section 375 subsection C. It is consent given under fear of death or hurt or obtained under a misconception of fact. You also can refer to the section 90 of Penal Code, said that it is not consent if it is given in consequence of fear or misconception. So in the case of In Chu Nang Hong, the accused invited her to enter the house after telling her that her husband was there. He then pushed her into a room and told her not to shout or else he would strangle her. She was shocked and dared not to put a fight due to his size. She was so frightened that she just remained still in the middle of the room until he undressed her and had a sexual intercourse with her. It was held that he was convicted for rape. Regarding to the misconception of fat, you can refer to the case of R versus William. In this case, a 16-year-old girl who received singing and voice production lesson from the appellant had sexual intercourse with him under the pretense that her breathing was not quite right and that he had to perform an operation to enable her to produce her voice properly. She was told that what is being done to her is not the ordinary act of sexual intercourse but is some medical or surgical operation in order to give her relief from some disability that she is suffering. The court held that the girl was persuaded to consent to what he did because she thought it was not sexual intercourse but instead a surgical operation. What she consented to was not sexual intercourse but the surgical operation which she thought would relieve her. Next, in section 375 subsection D stated that the belief that the accused is someone to whom she is legally married or would consent to. In the case of R versus Al-Bakai, the victim lived with a boyfriend. One night, her boyfriend and her accused returned home drunk. The accused climbed into bed with the victim who was half asleep and assumed that it was her boyfriend. Only when the accused penetrated her did she realize that it was not her boyfriend. The conviction for rape was upheld. In section 375 subsection E stated that the victim does not understand the nature and consequence of what she had consent to. This normally could also be mentally ill person. In the case of R versus Flattery, the victim and her mother consulted the accused for medical advice to cure her fits. After examining her, he told her mother that the nature string wanted breaking. She did not know what he meant but did not mind if it cured her daughter. The victim had a fight and the accused repeated the same thing. She then had sex with the accused believing that he was treating her medical and was performing a surgical operation. It was held that the accused was convicted as there was no evidence and the victim knew the accused was about to violate her person but instead believed that he was performing a surgical operation to cure her illness. Moreover, in section 375 subsection F stated that it could be invalid trust if the victim consent was obtained by the offender abusing his position of authority or trust. It could be casting, guardian, doctor for work promotions. However, the woman must not seduce him. He should start first. We can refer to the case of Augustine Fu Bongjang. In this case, the accused, who was the master of a maid, has established a position of a dominance over her as she was completely dependent upon him financially. She was afraid of doing anything which might prejudice her position and employment. Lastly, it was held that it was not difficult to see why she did not receive sexual intercourse as strongly as she should have, but only as much as she could. Lastly, regarding to the section 375 subsection G stated that it is rape to have sexual intercourse with a woman under 16 years of age, with or without her consent. Prosecution must adduce positive proof of victim's age. So in the case of Muhammad Fairuz versus PP, that when the victim is under 16 years old, her consent is immaterial even if she consent. In another case, in the case of Muhammad Saleh bin Nik Muhammad Yusuf versus PP, sexual intercourse with them was rape even with their consent. Absence of consent is irrelevant for proving the offence.
Last but not least is regarding to the punishment for rape under section 376 of the Penal Code, which can be divided into two. Firstly, section 376 subsection 1, where the punishment is imprisonment which may extend to 20 years and shall also be liable to whipping. Secondly, section 376 subsection 2, which is the enhanced punishment, imprisonment between 10 until 30 years and shall also be liable to whipping. The punishment under this section is provided where the accused causes hurt to her, puts her in fear of death or hurt to herself or any other person, or consent is obtained by using his position of authority over her.
Let it go, let my body go, make our bodies high.